So does that then mean that if you are going to the tribunal, you're applying on those 4 grounds?
You can go with as many grounds as you can substantiate. You know, so if you can substantiate that, for example, one of the tribunal judgments, I think, in Niger State was that the candidate who won the election was not of age. So that election was declared null and void. It couldn't it couldn't continue in that office. I think it was maybe House of Reps or something. So there are many grounds upon which a candidate who succeeds can be challenged. So one of it is that you're not qualified, because before you can be qualified to run for certain offices, there are certain conditions you must meet. So if you do not meet them and you go on and run and you win, your opponent can say, even though you won the election, even if there was no rigging, there was no malpractice, the Electoral Act was complied with substantially, your opponent can say, wait a minute, you are not even qualified in the first place to run for office. So,
in that situation, what should happen? Because it would seem, and it seems that that's what the PDP is saying here, that it did not change the fact that the people voted our party, that we garnered majority of the votes. What should then happen in that instance, if truly it is the party that people vote for, and it is the party that is gathering votes on that particular day?
The way to look at it is that, look, we're governed by laws. So if the law says that to contest for this office, you need to have 1, 2, 3, 4 requirements. We cannot allow a situation or a position whereby we sidetrack those requirements which you must have. It's just like saying before you become a lawyer, you have to go to university to get your LLB. You have to go to law school to be called to the bar. So somebody who doesn't do these 2 things would not be allowed to come to court to say, or to practice law. And same in most other professions. So the law says to be a governor, there's certain requirements. To be a member of the House of Reps, there's certain requirements. To be a senator, there's certain requirements. If you do not fulfill those requirements, even though in the election you scored majority of the votes, the law cannot overlook those infractions which are substantial. So for example, another way to look at it is, it says if you're not of sound mind, or you have been declared bankrupt, you cannot run for most of these offices. So how do we then allow somebody who is either not of sound mind, who has been certified not to be of sound mind, or who has been declared bankrupt, how do we allow him run for office and then govern us simply because the majority voted for him? He's not qualified.
What I'm saying is, shouldn't the party then be given an opportunity to produce another candidate since it gathered the most votes?
That is what the Electoral Act says, that if the issue is that of disqualification of the candidate, then there should be a fresh election.
In which case, is it then, I mean, and that's why a lot of people have a question mark on this election tribunal ruling, but is it then that the party will now be allowed to run fresh primaries, if they're going to be presenting another candidate, or what exactly should transpire?
That's a fantastic issue you just raised, because when I was looking at it, if your candidate, a party puts up a candidate who is not qualified to run in the first instance, and where the tribunal now orders fresh elections, I do not see how you can overcome that order, because there's a time frame and a time limit for party primaries, which has lapsed. So if the rerun is ordered, I'm not so sure, a candidate who is not qualified in the first instance can also participate
in the elections,
in the rerun elections. So that is the conundrum that this will even throw up. So let's even say you order fresh elections, and this candidate is not qualified in the first election that was held. It can still not be qualified to participate in the rerun. And it would mean that that party cannot present a candidate even in the fresh elections.
So that then makes this qualification a pre- and post-election matter?
Yes, it can be pre-election matter, and it's also a post-election matter. Because once you notice that a candidate wants to run for office and is not qualified, even before the elections are held, you can go to court to ask the court to restrain him from being presented as a candidate for that office. But assuming that, the elections have been held and this candidate also succeeds, you can also go to the tribunal to say that, no, he ought not to have been allowed to even run or contest for that office in the first instance.
Now, some people have said that, if you look at the testimony, as you rightly said, we're yet to see the full copies of the judgment. But then from reports that we gathered, it was saying that the tribunal based its judgment heavily on the testimony of INEC. And some people say that INEC, well, that's according to the Electoral Act, may or may not attend the conduct of the primaries, and it can even sneak in from the reading of that particular section. But then the next section, I think is it 86 or 87, also stipulates that INEC shall monitor the activities of political parties, yes. in which case it would seem that the section before that is neither here nor there. How do we read these two together?
In the first section, is talking about monitoring party primaries, monitoring inter-party elections. So it says INEC may, with or without notice to the party, attend the convention or the primaries or what have you. But on the other hand, it is mandatory for the parties to give INEC 21 days notice of any such primary convention that they want to hold. INEC has the discretion whether they want to attend or not, but in most instances they do. The latter provision you spoke about, the one that says INEC shall monitor, gives INEC general supervisory powers over parties to monitor all that they do, because it comes under their remit. So I think both provisions, in one, INEC has a liberty. In the other one, it is mandatory for them to monitor activities of the parties, even beyond conduct, because the first provision just talks about conduct of party primaries, party conventions, and what have you. But where the word shall is used is speaking generally about monitoring all their activities, even beyond them holding their primaries and conventions.
All right, let's flip to this other matter which broke yesterday, wherein we have a new head of the EFCC. I'm not wondering, because a lot of people will always say institutions functioning as opposed to just having personalities. But some others argue, yeah, personalities drive those institutions or make them function. Now that we have a new head, how do you see that affecting anything, in spite of all the laws we have for the EFCC to function with?
I've always thought that the efficacy of our investigative bodies, be it the police, the ICPC, or the EFCC, boils down to the body language, in quote, of the president. Because where you have a president who does not tolerate corruption, then you would see that whoever is in charge at these institutions, they are always up and doing. For example, during the Jonathan years, EFCC was a bit lukewarm with regards to prosecuting political office holders. But immediately come May 29, we saw a change. Even though it was still the same personnel, we saw a change in their activities. They stepped up prosecution. A lot of politicians were arrested. So it just goes to tell you that, they were not really independent. They're not really independent. So they look up to the man there, the president. They look at his body language. Is he going to interfere? Is he going to let us have a free hand? And I think that is largely what dictates it, which is unfortunate, because these organizations should run in accordance with the statute creating them.